Hello. I haven't forgotten you. Let me just get this fired up. Where's my mouse?
I did have a question.
Yeah.
What tutorials do you teach? Do you still teach tutorials?
I do, yes. I do Monday 12 to 1, Tuesday 12 to 1, and I'm covering an 8 to 9 on Friday, which is the final one. Yeah. I might do an announcement, and so it's the final one. I'll be doing it. See you there. We had no one turn up at 8 o'clock this morning, but to be fair, it was very crappy weather.
Yeah, I don't think many people were out of it this morning.
There's a lot of assignments falling due at the moment. That just
298. Which a lot of people are like having so much fun.
The microphone's off. What am I doing? I've got hay fever from all the pollen. Oh. Bladder, which I really ought to go into. Don't have time. Well, in fact, if I get you to do this, I might.
You will have time. I can kill time. I'm excited for party life. It's going to be interesting.
It's a lot more fun.
Yeah.
It's certainly a lot more fun to teach.
Faith was a bit of a struggle.
It's not my most fun topic, but look, in the last tutorial, students were definitely starting to look a little bit more interested and sort of looking as though they might get it.
Yeah.
Although I did, in a moment of madness, do an odd little impression of an elf in the back of the bank moving money.
If it works, it works.
It's really what I was thinking. But yeah, I did say to Julia, if you get a note saying, I think Lucy Holloway's losing the plot.
Don't worry about it.
Oh shit, my document's still processing. Come on.
I had to email Lucy. Not you. I had to email Julia because the voting thing went down.
Oh yeah.
And the person in charge of it wasn't answering emails. So I was like, come on, please help me. But yeah.
Right, so I have that. So now I just need to find yours, which I tucked into notices. There. How am I doing for time?
There's so many people here.
It's all right. Just look at the. So do you know Niccolo?
Yeah, I'll just look at one person up.
Yeah, so he's always a friendly face. Right, that's always a good way of doing it. No, I don't want to do that. Actually, that's not going to work. How do I just... why won't you just... just make it easy. Right, somebody's been playing with this today.
You can just leave it like that.
Sure?
Yeah, that's fine.
As long as, okay. That's right. I'll just hold on to my bladder and hope I don't sneeze.
It's okay, you can go. I'm sure.
That's right, I've got a bit to get through, so I don't want to...
Oh, yeah. Don't want to waste time.
No. I'll go on the break.
Oh, there we go. One of them's not doing so well.
No, it didn't come up that well at the back. Kia ora koutou, good afternoon everyone. Shay is just going to do a quick introduction of herself in relation to Council Student Rep, and then we'll get underway with parties.
Thank you very much. Hi, everybody. For those of you that don't know me, my name is Shay. I'm a Part 2 student just like you. I study an LLB and a Bachelor's of Science in Marine Science. And I'm one of your candidates for the council student election. For me personally, I'm running for this role because I want to make sure that everybody is heard and that things are treated equally and that everybody has a chance to have their say in regards to policies and things that might come through the council. But yeah, voting opened yesterday. However, there was a small issue with the form. So if you did vote yesterday, you will need to re-vote today because of that. But yeah, voting closes next week, Tuesday. And that's it from me. Don't forget to vote.
Brilliant. Thank you, Shay. All right, as promised, we are into our final topic, which I'm hoping you will find a little bit more exciting than property. So for the next 2 weeks, we're going to look at party liability. Today, I'm going to focus predominantly on Section 66(1). But I'll start the topic just by giving you a little bit of an overview as to what party liability is all about and how both Section 66(1) and 66(2) work, just as sort of a broad approach, big picture view, before we start getting into a little bit more detail, all right? So, but the main focus of today will be on Section 66(1). So what I want to do first is I just want you to have a quick look at this fact pattern and think about these people. Now, in an effort to try and make it easy for you to keep track of who is who, you've got A, B, C and D, and Vern, who is your victim, V for victim, right? So I've tried to make that simple for you. So just have a little look at this fact pattern and think, who is actually going to be liable for Vern's death? So I'll give you a couple of minutes just to think about that and maybe have a chat with the person beside you and think, well, who do we think actually would be held liable? For those of you at home, just have a little chat with yourself or the person next to you. And by the way, I'm sorry, I don't know why one side is blue and one side is black. I can't fix that. Okay. So we've got Bart is the spotter, right? Andy is the driver, and the person throwing the backpack is Cody, and Dave is the person who saw him and contacted them all and said, I've seen him, this is what you should do. They've all been involved in bullying poor Vern. So who's responsible for his death? So who thinks that it's going to be Cody who threw the backpack? Is Cody responsible? Okay, there's not too many people. All right. What about Andy who's driving? Do you think Andy's responsible? Well, that's even less. Okay. What about Bart, who's actually the spotter? He's the person. Oh, it's even less. What about Dave? Okay, not many people at all. They're all liable. Okay, under Section 66, they would all be liable. All right? So in all likelihood, as a prosecutor, you would go under Section 66 too. But I want you to think about this fact pattern as we start going through. And actually, the idea for this came out of a discussion one night at a dinner party, and somebody was talking about some of the things they did when they were at school that they were ashamed of, that they had picked on this guy when they were older at high school. And fortunately, it didn't quite pan out this way. They weren't in a car, but they did take his backpack off him. They did throw at him in circumstances that weren't very nice. He didn't die, but I did say, if he had died, you would have been responsible for his death. And they looked at me as if I was insane. So I very shortly explained to them the party liability principles, and I could see a few other people around the table looking very uncomfortable. Right? Party liability ropes in a lot of people in very unexpected circumstances, right? It is one that is worthwhile for those of you who are parents, for those of you who are planning on one day being parents, explaining to your teenagers in particular who get involved with people who might do stupid things, as you do when you're a teenager, and inadvertently get hooked in. Okay, so let's figure out how it all works. So the way in which we use party liability, it's about making a number of people liable for an offence in circumstances where they have deliberately encouraged or helped or assisted someone in committing the offence. Right? They don't necessarily have to have wanted the offence to have been committed, okay, but they intended to actually commit it. So that's really what Section 66.1 is more likely to cover. 66.2 is really more looking at circumstances where everyone agrees to do something unlawful and everyone plays a different part in that. Sometimes you don't even have to do anything, you just have to have agreed to do something unlawful and assist each other therein. And the way things then pan out is that you end up getting hooked into that liability. Okay? And so Section 66.2 we'll cover in more detail next week, but I will cover it briefly today so you can see the difference between the two sections. And it's about treating everyone the same. You are all charged with the same offence. Okay, and you are all liable to the same potential sentence. Now, as you've learnt about sentencing, your culpability may vary. Okay, but in terms of the offence that you have committed, you have all committed the same offence. Okay, so it's about everyone gets roped in, irrespective of the part you played, assuming that all of the elements have obviously been proven. Now, consider the example of a bank robbery, okay, and everyone's charged with aggravated robbery. So you've got 4 men who decide to rob a bank, and again, I've made it easy for you with an A, B, C, and D. Right, Andy goes and gets the guns, steals a car, and that's the car that's going to be used as a getaway car. Bert says, yes, I'll be the driver. I'm a great driver. Drives them all to the bank, and he stays in the car. Right, so he's the getaway driver. Carl agrees that he'll be the lookout, and Dave and Andy decide that they'll be the people who go into the bank. So Andy's got 2 roles. They'll go into the bank, and they will be the people who demand the money. They'll go in with the guns and demand the money. Andy will guard everyone with the guns, and Dave will put the money in the bag. Okay. Now, robbery is basically theft accompanied by violence or threat of violence. And then aggravated robbery is just on top of that. You've got robbery, but you've done it where you've got more than 2 people, or the violence or threat of violence has got involvement of a weapon of some kind. Right? So you're looking at aggravated robbery here. Now, everyone, as you can see, has played a different role in this bank robbery, but everyone gets charged with Section 235 aggravated robbery. Okay, even though they all played a different role. Right, so this is how party liability works, to ensure that just because people play a different role in offending, they still get charged with the same offence. Even though it's really only Dave and Andy that go into the bank. So looking at Section 66 now, this is Section 66(1) and 2 set out. So you're looking at, there's 2 scenarios where you essentially make a number of individuals liable for an offence in circumstances where they've helped or encouraged someone, so that's your Section 66(1). Okay, so you've aided, abetted, and we'll look at what those mean in more detail later, or incited, counselled, or procured, and there's often a lot of overlap between those things. And you've done it in circumstances where you've intended to actually help or encourage, okay? And you have knowledge that the person is going to do something unlawful. Right? So irrespective of who plays a different role, everyone gets roped in. Section 66(2) is a little bit different. We talk about a common unlawful purpose, or sometimes it's called a joint enterprise. So that is a different way of finding party liability, and that has different elements to it, and it has different mens rea requirements. Okay, so that is basically where you're looking at a situation where everyone decides to form what we call a common unlawful purpose or a joint enterprise. We're all going to do something unlawful, and then everyone is then liable for whatever happens in the commission of or in the happening of that unlawful purpose. And where Section 66(2) has traditionally been used was to capture situations where in the commission of that common unlawful purpose, so where everyone sort of was carrying out doing what they had agreed that they would do, somebody does something worse. They go into the bank with a gun, okay, and the idea is that we're just going to go in and get the money. All right, but Dave's actually a bit of a hothead, and Dave ends up shooting someone, okay, and the person dies. Now, if everyone knew that Dave was going in with a loaded weapon, everyone is liable for the death. Okay, everyone is liable if it's manslaughter or if it's murder. If they can prove murder, then everyone is potentially liable for at least one of those offences. Okay, so you end up getting caught up in where something worse happens. Niccolo.
Just like, for example, though, say that all the guns loaded with weapons, so there was no fatal specific murder, but he loaded his guns with real bullets and nobody else knew about that. Would they still be liable for a death?
Not necessarily. So so we will look at what sort of knowledge is required, but Section 66(2) allows recklessness, all right, conscious appreciation of the risk, but ran it anyway. So it's a lower mens rea. There's a lot of case law about weapons, what you knew about the weapons, etc., etc. So we'll cover that next week, but the court have flip-flopped quite a lot on that. Yep. And there's been a recent, very important decision, I think it came out last year, from the Supreme Court on this exact issue. Yeah. Really, really interesting area of the law. And if anyone's interested, I'll talk about it more next week, but the hearing in the Supreme Court was actually streamed live, and so you can go onto the Supreme Court website and watch the hearing in the Supreme Court where they argued it. And you can look at the submissions from all of the council, which is interesting as well. So there's various ways in which you can be held liable for an offence. All right, so we've really only looked at liability for someone as what we call a principal party, where they've carried out the actus reus and the mens rea of the offence. So that is really where our main focus has been all year. Has the person carried out the actus reus and the mens rea of the offence? And that's what we call a principal party. So if you've got one person who's done that on their own, we don't bother looking at Section 66 because we're not trying to rope someone else in that liability as a derivative liability. But where we've got someone else involved, then we have to identify our principal party, the person who actually carried out the actus reus, mens rea, and then we've got these two separate ways of finding derivative liability for what we call a secondary party. So we've got this Section 66(1), where we're looking at someone who's helped or encouraged or assisted, and they did it knowing the type of crime that was going to be carried out, and they intended that encouragement. Okay, and Section 66(2) is where you've joined others in a criminal purpose, and you can be reckless. Right? So there's a different mens rea element. You can see it's less. So you can be liable as a principal, or you can be liable as a secondary party in two different ways. Now, we're going to cover this shortly, but if you don't satisfy any of those, but you somehow get involved after the fact, you can still be liable as an accessory after the fact. All right, so somebody comes to you and goes, "Oh no, I've just killed someone. I need your help to bury the body." Okay, the commission of the crime has happened. You can still then be liable if you assist that person. So I guess the question is, for you, does it really matter which section you use to establish party liability? Yes, it does. It matters very much. Okay, because when you're looking at Section 66(1), you actually have to have assisted or encouraged. You have to have done something. Under 66(2), you don't. You just have to have agreed to join up to the common unlawful purpose. Okay, so it's a very, very different thing. Under Section 66(1), you have to have knowledge and intention. Under 66(2), recklessness suffices. Okay, so your mens rea requirement is much less. And the reason for that is because the courts have said, well, we're quite happy with these much more relaxed requirements under Section 66(2), because a person has already agreed to do something unlawful, okay, and they, as a result of that, they therefore become liable and responsible for anything that progresses as a result of that common unlawful purpose. That's the chance they take. Right, so we're quite happy to have these much more relaxed requirements. So if you think about our bank robbery case, our principal parties here carrying out the actus reus and mens rea requirements of aggravated robbery would be Dave and Andy. Okay, you've got someone who's doing the threatening, and you've got someone who is taking the money, and your secondary parties would be Bert and Carl, okay, because they're not the ones committing the actus reus and mens rea. So there's just your rationale for why we have this lower recklessness for section 66(2). The idea being you just have to take whatever flows from that agreement to signing up to the common unlawful purpose. And you'll see as we look at this next week that how you set that common unlawful purpose becomes very important. So as I said, everyone is liable for the same offence, and it's a general provision. Now, I'm going to stress this because students every year say this person could be charged with section 66. Section 66 in and of itself is not an offence. Okay, section 66 has to be combined with an offence. Okay, it is a general provision, but it combines with an offence showing that you are making this person liable, or you're trying to establish this person's liable for an offence via derivative liability, via party liability. And because you are having to establish liability, which is derivative liability, as I said, you must establish that you have a principal offender. If you cannot establish that your principal offender has committed the actus reus and mens rea of the offence, then you cannot derive liability from that principle. Okay, it's very, very important. Just very briefly touching on accessory after the fact, which is established in section 71. Essentially, this works where a person provides some kind of assistance or comfort, or maybe tampers with some evidence, suppresses some evidence against the person who comes to them, or they become aware of that they've committed this offence, and they have to have knowledge that they've committed the offence, and they have to have an intention to help them escape liability. Okay, so just always bear that in mind as you backstop if you can't actually prove liability for a secondary party. Now, the leading case here is the case of arson. It is in your reading list. Obviously, the facts of cases, as you know, are not particularly important when you're looking at general principles, but I do want to run through the facts of this particular case because I want you to see how much the court roped the two women. So the focus of my factual scenario here is really on the two women, because the arson case involved one of the women, roped these two women in to this offending. So essentially you had four people driving around. Two of them were gang members, patch gang members. One of the women was they were quite young women, was in a relationship with one of them, and the other one was just sort of an acquaintance. And they were driving around, and really they were looking for trouble, and that they were getting into altercations with various people in various parts of the day. They'd got into an altercation with some people in a car park. So they were Black Power. They got into an altercation with some mongrel mob members. Police got involved in that. They found a spanner in the car of one of the mongrel mob members, which later got thrown up the car where the defendants were in. And later that night, they got involved in a sort of around 8 p.m, so it wasn't particularly late. They got involved in another altercation down by the river where they were shouting gang slogans at people, and there was a threat with a knife. but no actual violence occurred. They were driving to a party and they saw a very, very drunk man walking down the road. And they thought that he was a mongrel mob member. And the woman who was driving did a U-turn, pulled up alongside him, and he, in his very intoxicated state, was confused and thought that they were, I can only assume that they were going to pick him up, give him a lift. He tried to get in the car. Now, the four of them got out, pulled him out of the car, and the two men started punching him. And one of the women was screaming, "That's enough, let's go." Okay, trying to bring the violence to an end and get out of there. Now, this is the man that they had seen walking down the road that was very intoxicated. So this is the victim. Not a particularly old man, right? He's a very young man, very tragic case. He's just walking down the road. Now, one of the men, during the assault, went back to the car and he got a short-handled axe and he hit the victim repeatedly on the head. The victim fell to the ground and he died of his injuries later. Now, one of the women the evidence was that she was screaming continually, telling the men to get in the car. They jumped back in the car and they drove away. So the two women were not involved in the assault at all, and the evidence was that they were trying to, although they were involved in trying to get him out of the car and had been involved in shouting gang slogans and things during the day, they weren't involved in the assault at all. Now, the guy who had hit him with the axe went down for murder, and the other man and the two women were also charged with murder. So the women were being charged on the basis that they had alternatively, under section 66(1), assisted and encouraged in the assault, that they had assisted by driving the car and pulling alongside, that was Ms. Arson, and that there had been some encouragement of the assault while it was being carried out by Ms. Ramaka. So this is the two women here. You can see how young they are. Alternatively, they were charged under 66(2) that they had entered into a common purpose, right? That the common unlawful purpose under section 66(2), and that common unlawful purpose was pitched as being to intimidate and assault members of the mongrel mob that evening. And in carrying out that common purpose, this person had been killed, and everyone was therefore liable for his death. So the women were initially both convicted of murder, right, even though they hadn't actually done anything. And this is how wide party liability stretches, right? Because they hadn't actually physically done anything to hurt the victim, but they were both convicted for his murder on the basis of their encouragement or that they had signed up to the common unlawful purpose. Now, the matter went, this was in 2008, I think it was, the matter went all the way to the Supreme Court. By the time it actually got to the Supreme Court, it was many, many years later, and in the meantime they were sitting in prison. Ms. Arson ended up pleading guilty to manslaughter in 2015 as an alternative charge, and Ms. Ramaka in 2016 was actually found not guilty altogether. So when the Supreme Court looked at it, right, when it came before them, they said the decision was wrong. All right, they said that the application of the law in terms of holding these two women liable under either Section 66.1 and Section 66.2 was incorrect. But in the meantime, these women had sat in prison for many, many years. Okay, and remembering that one of them ended up pleading guilty to manslaughter and the other one ended up being found not guilty altogether. Okay, so this is party liability in New Zealand has stretched very, very far. So the Arson case is an interesting one to read because it looks very carefully at the way in which our law has developed, but it also does some interesting things, and I put that in inverted commas, in terms of the way in which we apply Section 66.2. Okay, because traditionally we've only ever used it where someone does something in addition to what was intended, but the court extended it to be applied even where what happens is what is intended by the common unlawful purpose, bearing in mind, of course, that you've got a lower mens rea. So it's an interesting case. So let's focus our attention now on Section 66.1. Okay, and we're going to look at the elements which are set out by arson, right, as being the elements that are now followed for Section 66.1. So as I said very clearly before, you must show that you've got a principal who's actually committed the offence itself, right? Actus reus, mens rea. That's your starting point, always. You have to show that the secondary party, and you can have more than one principal party, but if you're relying on a secondary party, you have to show that they aided, abetted, incited, counselled or procured, and we're going to talk about what those means, but essentially you're just showing that the person encouraged or assisted in some way the commission of the offence, and they can do that either by words or conduct. Okay, so those are your two actus reus requirements. The mens rea is you must show that they intended to aid or encourage, and that they knew both the physical and the mental elements of the essential facts of the offence. Okay, so that's the actus reus and the mens rea elements of the offence. Okay. So just to simplify that for those of you that a lot of words in there, so let's just take out some of those words. So principal party is quite often just shortened to PP. When you do this in your exam, if there's a question involving party liability, and the thing about parties is we can slip this in anywhere. Okay, we can put this with interpersonal violence offences, we can put this with property, okay, we can put this into any offence because it's a general provision. We can attach it to anything. I see by your faces that you go, oh, great. Right, so you can shorten principal party to PP and secondary party to SP. I would just suggest if you do that, that you tell us that's what you're doing first. So again, offence has to be committed by someone. You've got to show that the person is aided or encouraged in some way, right? So done something to assist. They had to intend to do that, and they have to know the physical and mental elements. Okay. Now, for those of you that prefer to have things in a more visual thing, I've just created something a bit more visual just to make life a bit easier for you, for anyone who finds that an easier way to have a look at how this all works. Right? It's the same information, just in different formats. Now, when you're looking at party liability in terms of your actus reus under Section 66.1, there's timing issues, and I've just summarised that, but we'll get into the detail of it in a minute. The aiding, abetting, inciting, counselling, we will delve into those terms, but really this idea of encouraging someone or assisting someone, okay, it has to either happen prior to, so it has to happen before, or contemporaneously with the offence being committed. Okay, if it happens afterwards, you're an accessory after the fact. But you're going to see in some of the cases we look at that the courts are really keen to try and fit you into this prior to or contemporaneously with. And when you're looking at mens rea, you've got to have this intention alongside the knowledge. So let's look at our first element from arson. Let's look at what it means to be a principal party. Okay, so as I said, because it's derivative, you've got to actually show that you've got someone who has actually committed the actus reus mens rea. And where it starts to get a little bit complex is where you have more than one principal. Okay, so if you have someone that really should be a principal party and you put them as a secondary party, you can imagine when you come to sentencing that you haven't actually quite identified the culpability right. Okay, so that's figuring out who's actually responsible as a principal and a secondary is quite important. So you can have a number of individual principals doing the same crime. You can have joint principals, okay, where they act together to do the crime, where one does a different part of the crime. And you can have a principal acting through an innocent agent. So looking at that in a bit more detail, when you're looking at an individual principal, this will be where you've got more than one principal, where they each commit the actus reus and mens rea. Sorry, each commit the actus reus with the required mens rea. Okay, so you've got a number of people, for example, who are attacking a victim at the same time. Okay, they're each performing the actus reus, whatever the offence it is that you're charged with. Now, when you're obviously looking at offences where you're having to identify the level of harm caused, then sometimes that can get a little bit tricky, but in terms of your causation issues, where you've got two principals, where you've got individual principals both committing the actus reus mens rea, sometimes you don't necessarily have to show exactly which harm was caused by which person. Right? You just have to show that you've got actus reus with the requisite mens rea. Right? So that's your individual principle. So you would have two separate principles. You can have joint principles, and this is like our bank robbery situation. Okay, where you don't necessarily have two people doing exactly the same thing at the same time, but together what they do commits an offence. Okay, so they separately wouldn't actually satisfy the actus reus and mens rea of the offence, but together they do. Okay, so for aggravated robbery, as I said, you've got to have theft with a threat of violence, and you've got to have either two people or you've got to have use of a weapon. Now, if the person who's committing the theft part, you all know what that means now, if you've got one person committing the theft part and the other person doing the violence part, right, the threat of violence with a weapon, together they make up aggravated robbery. It's pointless to charge one person with theft and the other person with some kind of assault with a weapon, because that's not really a true reflection of what's happened. Okay, so we treat them as joint principles, and we charge both of them with aggravated robbery as joint principles. Okay, and this is particularly important where you've got fraud transactions, where you've got a long sort of standing series of events. There's no point in charging the person at the end. You've got to charge sort of everyone along the way. In the case of Namu and the Queen, this was a cheque theft ring. Now, I know that you don't use cheques anymore. A cheque, for anyone who's not familiar with it at all, used to have a thing called a chequebook, and it was a piece of paper. You filled that out, you put who it was for, you put the amount on it, and then you signed it, and a person could go to the bank and hand it over, and depending on how it was filled out, they either have that money banked into their account, or you could actually get cash for it if it was a cash cheque, right? And so a huge amount of cheque fraud. I mean, you could easily, well, depending on what your signature's like, but you could easily forge other people's signatures. Right? So this was a big cheque theft ring, and so some members of the group were responsible for stealing the cheques, others for altering the payee information. Other people were responsible for finding other participants to bank it, or other people who were willing to allow their bank accounts to be used for that purpose. Okay, so there were lots of people involved in doing different things, and to charge them separately, it was like, what do you actually charge each of them, one of them with? Because then you don't actually get the true offence of what they're actually all doing. All right, so they were charged as joint principals, and they were charged under 228, right, which you should all remember, be familiar with. Okay, dishonestly using a document. Right, so it didn't matter that each of themselves didn't actually commit the actus reus and mens rea, altogether they did. Now, sometimes you can also act through an innocent agent. Okay, so you can be a principal by acting through someone who's actually innocent. So this was a case of Queen and Patterson, where a guy sent someone to go get a TV. He said, look, can you go get this TV? Here are the keys. And then drop it off to this place. Right? This person thought they were authorised to do this. Completely innocent. Right, so they went into the person's flat, got the TV, and then they got a bit suspicious and went, no, something's not quite right here, and then went to the police. Okay, now they weren't charged as a principal. The person who had instructed them to do it was charged as a principal. They weren't charged as a secondary party. Okay, the principal had acted through an innocent agent, even though he hadn't actually committed the actus reus or mens rea, with the mens rea. Right? There are some exceptions to that, or actually there's another case, Narayan in the police, where an accused punched his partner who was holding their 19-month-old son. She fell on the ground with the child, and the accused was guilty of an assault. So he was found guilty there were sort of two ways of doing that. So acting through an innocent agent, in fact she was holding the child, so she was the innocent agent, or an assault indirectly would have been the other way of doing it. Okay, but it was another example where they said that he was acting through an innocent agent, being the mother. Few exceptions to that is where you might have a person who is protected by liability as a result of some kind of defence. Okay, so that is one of those situations where you've got to be thinking about, have I got a principal party? So if self-defence, if the person who is charged with committing the offence as the principal party has got a defence of self-defence, then they haven't committed the offence and you can't derive liability from that. Okay, so always bear that in mind. Okay, looking at our second element, which I'm going to do after the break. Right, so take 10. You all look at me like, she said parties was more exciting. Take 10 minutes. 10 minutes. 10.
America has a loophole system, which is for big organizations that require to go and get them into a really far removed. Do we have any example, or is this our past about it?
In relation to what kind of
I know some kind of drugs, legal, that's what envision for. Now, what is it? It's rapturing organized crime. And it's so if someone's organizing crime but not actively taking part in it, they can also be they can face some charges they can quit.
yes, that would be more likely to be under Section 6. So in terms of, we have our similar would be the serious fraud. But yeah, Section 66 duty has been used in those circumstances when you've got, because provided everyone signs up to the common law then the and you will agree to resist each other in the whatever happens in the so what you have to do is prosecute establish what criminal evidence is and who's the subject. So that's how you would do it. So you don't actually in terms of fraud, that's I would tend to be.
For 661, it's like a degree separation. Like you have to do one degree to offender, or it doesn't matter how far. Who do you do that?
Well, it really depends because you have to have done something that either aids them or assists them with coverage.
If you're talking about a secondary or secondary party, would that make you liable as a secondary party?
It really depends on the circumstances. Okay, let's get underway. So your first element, just to recap, is obviously that you've got to show you've got a principal party. Your second element, under section 66(1), you've got to show that your secondary party actually aided, abetted, incited counsel to procure the principal party in the commission of the offence. Okay, so we're going to look at what those things mean, and there's always, or quite often, a lot of overlap between them. Essentially, when you're seeing these words, so they come from section 66. 1b to d, it really is just, has the person assisted or encouraged? Okay, procured has a slightly different meaning, but predominantly you're looking at circumstances where you're looking at, has the person actually assisted or encouraged in some way? You don't always have to specifically set out what it is that you are relying upon in terms of section 66 1b to d, but sometimes there will be different timing requirements or different appreciation of the result. So otherwise, yeah, that will only be the only difference, but more often than not, particularly when you're looking at aiding and abetting, okay, it's okay to say aiding and abetting, right? They do, however, have different meanings. In the old law, they were quite specific about them, so I will actually cover what they mean specifically so that you have a better understanding. Just remember, your central question to ask is whether the defendant did, in fact, help the principal party. Okay? Now, when we're looking at aiding, we are looking at assisting, helping, or giving support. And the cases have made it very clear that for this to suffice, for you to satisfy this requirement, it must actually have the effect of giving assistance. But as you will see, what suffices for giving assistance is incredibly slight. But you must actually point to something which gives assistance, okay? Just remember that. So supposedly, under the law, if you try to give assistance and you fail, that should not be enough. But the courts are very, very keen to show any assistance as assistance. Now, in Larkins and Police, it is an old case, but it is one that we rely upon time and time again. This was a case where there was a guy, and I suspect he was a bit of a doofus. So he heard at a party a group of guys talking about doing a job on a bottle store. All right, so he didn't know them, but he decided that he was going to try and help. So he went to the bottle store later on, and he saw these men standing outside in front of the building. And so he decided he was going to be the lookout. And he admitted, when spoken to, Defence Counsel's dream, that he would stand as a lookout. That was his plan. And that he would alert the men had he seen the police coming. Now, whilst he was standing there, somebody yelled cops, and he actually ran away. And he was later apprehended by the police. But your doofus doesn't really quite cover it. In fact, I think he was even looking in the wrong direction, if I remember rightly. And in actuality, by the time he got there, the offence had been committed. Okay? They'd actually already gone into the bottle store and committed the burglary, and it was done. Right? So really, he should have been charged as an accessory after the fact, but they charged him as a secondary party to the burglary. And he was convicted at trial, and he appealed, so he at least did get a decent lawyer. And his conviction was quashed, and he was found guilty as an accessory after the fact. But what is concerning about this particular case. I can't remember if I gave you the slide on this or not. I did, okay. What is particularly concerning about this case was what Justice Eichelbaum said in relation to what would have amounted to assistance from him. So, in particular, when he was talking about what would amount to assistance, had the burglary still been going on, was that in his opinion, that the prosecution's submission that the appellant, in standing there as an extra pair of eyes, was at least evidence of actual assistance, regardless of whether the people inside, so the offenders, knew he was there or not. So it's hard to imagine how that suffices as actual assistance, because they don't know he's there, so that doesn't give them any sort of sense of comfort. Okay, well, at least we've got him as a lookout. Had they known he was there, I'm not sure that they would have had any comfort anyway. But if they don't know he's there and he's not done anything, right, then you would think that that might fall into the bracket of he's tried to assist and failed. Right? If they knew he was there, it would have been different, but they didn't. Right? But Justice Eichelbaum in this case was prepared to say that that would amount to actual assistance. Okay? And we have treated this as quite significant authority and followed it thereafter for some time. Okay? And it's never really been questioned or overturned in terms of what amounts to actual assistance. When we're looking at abetting, we're looking at an encouragement by words or action. Okay, so it can be conduct. So thumbs up is good enough. Someone clapping. Someone even laughing can be seen as encouragement. But it's a general rule that the person committing the offence, so your principal or principals, must be aware of the encouragement and must act within the scope of it. Okay, if they act outside the scope of the encouragement itself, then you are not liable for what they do outside of what you've encouraged. But you need not show that your encouragement caused, or the prosecution need not show, that the encouragement caused the principal to commit the offence. All that needs to be shown is that the principal offender is aware of the encouragement. Okay, you don't have to show some kind of causal link. So in the case of Queen and Shrek, this was a Shriek. Sorry. I do need new glasses. This was a case where there was an assault and there were people watching on a closed circuit TV system. And they were indicating their approval by sounds and gestures, etc. So that would be encouragement, except that the principal offender couldn't see them or hear them. Okay, so that wasn't considered to be encouragement, right, because he wasn't aware and therefore couldn't be encouraged by it. The courts have also said that mere presence is not enough. There's got to be something in addition to just your presence. But the courts have been quite keen to look at conduct And the slightest conduct, in addition to presence, will sometimes be considered to be enough. So in Queen and Coney, attendance at an illegal prize fight was considered to be evidence of abetting battery by the fighters, simply by watching it, as that was considered to be encouragement, although they needed to show, in that case, that there was mens rea, and I think it might have failed on that basis, that they intended to encourage. But it's hard to see how, this is an English case, it's hard to see how there's a distinguishment between mere presence or whether or not the act of the conduct was actually in turning up to the fight was the conduct that they considered was enough to extend beyond mere presence. Okay, but the courts are, and you can see what I mean, how party liability is really stretched to catch people in. Right? The courts are really keen to use party liability to try and capture people. When we look at incitement, now this is where you have to persuade or induce, coerce, and it quite often overlaps with abetting. Sometimes it's sort of been considered to be something which is a little bit stronger than encouragement. But I guess you could say there's some sort of idea of you exert a little bit more pressure, perhaps, than an encouragement. So in Young and Castles, they said it's to rouse, to stimulate, to urge, to spur on. So I guess you would really strong encouragement. Right? You can see how there's a lot of overlap and why you don't particularly have to identify these things all the time. Now I imagine this was a particularly embarrassing situation for the police, in this case of Bernard and the police. So this was in Timaru, and so quite a small town, makes a difference. So this guy was involved in a fight in the pub, police arrived, and he was put into the back of the van. Now, the police very foolishly didn't take his phone off him. And he phoned 4 of his friends who turned up. Right? They were gang members. They all turned up and they were standing around. So while he's in the van, and police officers are all there, these 4 guys are standing around. Right? And they start... the accused started saying to the police that they should let him go, and if they didn't, their houses would burn. That's a quote. Their houses would burn and his boys would do the business for him. And those comments were all made in the vicinity and earshot of the 4 men. Who then joined in to the effect that apparently there were comments made that they knew where the police lived. The idea obviously being, we're coming after you. Now, they were all convicted of an unlawful assembly, which is really, when you're looking at that, it's about assembling to cause people in the neighbourhood to fear on reasonable grounds that violence may be used. Right? And he said, but hey, I'm in the back of the van. What was I doing? How could I be guilty of this? I wasn't involved in any kind of unlawful assembly. And the court said, no, your words that were conveyed to the people, to your 4 men, incited and encouraged them in their assembling in the way that they did, which then incited the fear of violence. Because that was enough to charge him for incitement, right, as a secondary party. Okay. When you're looking at counselling, Counselling really is about providing advice, okay, advice or information. This is really about helping someone by giving them some sort of information that might assist them in the commission of the offence. Right, so, you're breaking into the bank. Okay, well, that's quite a hard safe to break into. I've got some instructions that I downloaded from the dark web. Right, pretty clear counselling. It's actually an offence to assist someone to commit suicide, so providing them with some kind of information about how to do that would also suffice for counselling. So as you can see, there's a lot of these things do overlap, and really the only one where it becomes one that's a bit of an outlier is procuring. Procuring is different because you're actually trying to achieve a result, whereas the other ones, it's more about you're just actually trying to encourage or assist. You're not trying to achieve the commission of the offence itself. When we come to mens rea, you'll see why that's important. Procuring is actually about trying to produce something by endeavour. Setting out to see if you can make the crime happen. So the implication being that you are inducing someone to do something that they would not otherwise have done themselves voluntarily. So sometimes it can be by fraud, it can be by coercion, but not sufficient to obviously meet compulsion. And there's got to be a causal link between the procurement and the offence, in the sense that the offence was committed as a result or as a consequence of the procurement. Okay, for the aiding, abetting, counselling, inciting, that's not required. There's no causal link required. So you've actually got to prove the secondary party's actions that they took, but you don't need to show that they were necessarily the decisive cause of the offence itself, so long as they are influential or some cause to a significant extent at least. Now, we don't actually see many cases dealing with procurement. Probably the one that makes it most clear is where this person was charged as a secondary party, was lacing a woman's drink with alcohol. She didn't know. And she was then charged with driving drunk. Right? So he was trying to bring about the commission of the offence of driving with excess breath alcohol. Okay, so it was his endeavour to bring that about. He obviously was a significant cause of the commission of the offence, and therefore he could be charged as a secondary party for procuring. Now, timing is important because of this idea of if you come after the fact, you're an accessory. So when you're looking at each of your aiding, abetting, assisting, etc., you've got to think about the timing. So your assistance or encouragement must be provided prior to or contemporaneously with the commission of the principal offence. But as you'll see from the Larkinson police case, the courts are quite happy to be quite liberal in how they consider what is contemporaneous. But in that case, as it transpired because the offence had actually been completed when it went on appeal. They said, well, he can actually only be an accessory after the fact, because by the time he got there, the offence had already been committed. Right? Had he got there a little earlier, his extra pair of eyes would have sufficed, but he actually got there after they'd come out of the bottle store, offence complete. He's an accessory after the fact. Now, timing can be stretched a little bit far. A good example of that is the case of Turanga, where we had 2 getaway cars. These were obviously very organised people. And she was the driver of the second getaway car. Okay, so this was an aggravated robbery. And the second getaway car was situated some distance from the place where the robbery took place. So they got into the first car, they drove to the place where the second getaway car was, they all jumped into the second getaway car, and off they went. Okay, the old switcheroo. Right, so Defence Counsel argued that the actual offence had been completed by then, and therefore she should be charged as an accessory after the fact, right, which is a lesser offence. And the court rejected that, and they rejected that on 2 bases. The first being that the arrangement to have a second getaway car was made prior to the offence being committed. Right, so they said that provided everyone with this extra feeling of reassurance that they had these 2 getaway cars. So contemporaneous assistance in that case meant that you could extend the time so that it was belonged to the same time or period. It doesn't have to be exactly the same time. They were prepared to take it beyond the minute or 2 after the robbery, not just in terms of the time, but also the location. Now, whether they would have taken the same approach if it hadn't been decided prior to, I would have said not. Okay, so the 2 reasons I would suggest fit together. Okay, they extended the time and the distance because the arrangement was made prior to. But if you compare that to a case like Kahuroa, now this was a situation where this person was alleged to have become involved as a party for aiding and abetting. By standing guard and providing tools and the court said that in that case the offence was complete at the particular point of entry into the building. Right? So you remember burglary, entry can be literally a hand over the windowsill. It can be something that you've used to break the window. Anyone see the news this morning where they've charged a guy with breaking the window at Winston Peters' house? They're charging him with burglary. Didn't go inside, but he broke the windows, right? So they're charging him with burglary. When I saw it, I was thinking, I hope all my students see that and go, I know why it's burglary. Because entry can be even the slightest little fingertip or the thing the person's holding, right? So in that case, the fact that he was standing, he had these tools, so the burglary was committed at the point of entry, and they said it's complete at that point, and therefore he wasn't a secondary party. Now, Queen and George, I think, is a really interesting case in terms of where the court have really been prepared to be liberal. And this was an importation case where this guy's nephew was supposed to be picking someone up who was importing drugs, picking them up from the airport. And he said, look, if he can't do it, I'll do it. Right, the offer was made while the person was still in transit. And the court said, as it transpired, he wasn't needed. Right? The nephew was able to do it. The court said he was guilty for aiding and abetting because the importation was not over and done with until they reached their final destination. And by being a backup, he had provided assistance and encouragement because there was this feeling that at least if something fell through with the nephew, everyone knew that it would be okay, essentially. Now, I can't see how you would distinguish that from tried to assist and failed, because he didn't do anything other than make an offer. But the court said, no, that's enough. Right? That provided encouragement that actually, if plan A doesn't work, we've got plan B. That will be aiding and assisting, aiding and abetting. Now, just remember, in terms of your connection, aiding, you've got to have assistance provided in fact. So this is really just summarising what we've talked about. Okay, for aiding, you've got to have assistance provided in fact. Okay, your case is Larkins. For abetting, inciting or counselling, you don't need to show causation, but the person must be aware of it, although they need not actually act as a result of it. They just have to be aware. And for procuring, you've got to have some causal link between that's not very good, is it? Between what the person did and the offence. All right, so that's just showing your different assistance and encouragement, etc., your section 61B to D, and what you've got to show for it to suffice. Right, and just remember, mere presence is not enough. You've got to point to some measure of encouragement, but that encouragement can be quite small. It can be the circumstance, like it was in Coney, yep.
Personally, do you think Tom struck the correct balance there? It's not too expensive.
Sorry?
Do you think Tom's struck the right balance? This isn't all too expensive in a way?
No, I think it's way too expensive. I think it's terrifying. Yeah, I think we've gone crazy with party liability. This is our mens rea requirements here, at least intention and knowledge of the mental and physical elements. But when you get to section 66.2, it's even worse. Yeah, and a lot of academics looking at this and just going, where are we going? Arson just blew it out completely. Yeah, no, it's, and when you've got children, when you've got, it's terrifying, frankly. You think about your factual scenario. Obviously I made it up, but you think about your factual scenario where you what do I call him, Mr. Winiata, right? You got convicted for GBH at, 19 or whatever it was, for standing around, and, that was a classic case of party liability. And you all argued that he shouldn't be punished for that. Well, this is one of those, this is how party liability works. Yeah? Frightening. By the way, my children have never been convicted of this criminal offence. Just so you know. Right. That's just really covering Coney in a bit more detail. Sorry, I've just looked at the time and thought I'd better get on to our mens rea requirements. But a little bit more description on Coney for those of you that are thinking about mere presence. Just the extent to which the court are prepared to look at how mere presence with some kind of conduct is enough to say, okay, well, we will now treat this as some kind of encouragement. The facts of this case aren't particularly important in essence, but really what Evans and Commissioner of Inland Revenue made very clear is that when you are looking at presence and a failure to act, they made it clear that it is in fact a question of fact. Okay, so it's obviously a question for the jury, but some of the examples, as I said, are things like presence and laughing, where being present means that so someone is beating someone else up and you are there, which means that the person is less likely to resist because they feel outnumbered, has been considered to be enough. Where the previous relationship and conduct between the parties is enough to say that they have read that presence as being encouragement. And then in the case of Cooper and the Ministry of Transport, they've said that a person who was driving a vehicle and where a person was sitting in the passenger seat and the person who was driving the vehicle beside them was driving badly, that meant that they were also liable as a secondary party because their mere presence had encouraged the person because it was their vehicle and they therefore had control over it. Now we would charge them for an omission under Section 156, having a duty of care, etc. But this was where secondary party liability was used. Now, you might start to see how party liability was actually used in the case of Whittaker. Now, this was I don't know if any of you have read the Whittaker case. It's one of those cases that if you read it, you never ever forget the facts of it because they're so horrific. Now, in that case, in terms of holding her liable, so this was Delcelia, so she died from the most horrific ongoing abuse. And in the end, what killed her was a blunt force trauma to the abdomen, which ruptured internal organs. And Tanya Whittaker was charged on the basis that she had an awareness as a secondary party. And when the court looked at it, so I've bolded the words for you, but the court on looking at this went, if either the mother, so this is how they bound them in as parties, right? So this is prior to our Section 152, where we've got the requirement to protect from injury. And so this is how they established liability here. They said either the mother or the de facto father had knowledge of the propensity for one of them to commit violence and had knowledge that there was a risk of that violence and did nothing to stop it, then that was read as encouragement and it was read as an intention to encourage those acts such that they then became liable as a party. Now, I don't know if you remember, but Tanya Whittaker was also herself subject to terrible abuse. But they basically treated her failure to do anything, along with her knowledge that there might be ongoing violence, as an intention to encourage, and vice versa. That his awareness that there might be violence being committed and his failure to do anything was encouragement. So in that case, it wasn't even mere presence, it was a failure to do anything. So the courts have shown that an omission can also be treated as an encouragement. Now, as I said, obviously now we would go under 152, but you can see how much party liability has been stretched to achieve liability by saying that a failure to do anything at all is in fact treated as encouragement. Now, when we look at our mens rea requirements, you've got to intend your conduct, and you must intend, if you're aiding or abetting, you must intend to assist or encourage the offending. Now, we're going to have a look at this in more detail. You must know the essential matters of the offending. So intention and knowledge are required. Recklessness is not enough. Okay, so you're looking at intention to assist and encourage with knowledge of the essential matters of the offence. Okay, so those are your two mens rea requirements. Recklessness doesn't suffice. So when we look at intention, what's really important that you understand here is that you don't have to intend the commission of the offence itself. You just have to intend to do the thing that encourages or assists. And the best case that shows that is the case of Wentworth. So in that case, this was a pharmacist, and he was selling codeine to a young woman who was coming in, and he knew that she was using that to make home bake heroin, or some kind of morphine or some derivative from the codeine, right? A criminal offence. Now, he knew that she was being coerced and pressured by, I can't remember if it was gang members, but it was certainly people that were putting her under a lot of pressure, and he felt sorry for her. Okay, so he didn't want her to commit the offence of creating the drug, but he wanted to help her. So by selling her the codeine, he was trying to assist her. But he knew what she was doing with it. Now, the court said it didn't matter that he didn't actually even want her to carry out the offence, that in fact he really didn't want her to carry out the offence. His intention was to assist her, and that's all that must be shown. Okay, so that distinction between intend to assist is totally different to intend for the commission of the offence. You may not even want the offence to have been carried out. Okay, so make sure you understand that distinction. If you're struggling with it, read the Wentworth case. I think it's one that I've put on your reading list. Okay, so you can do something that actually does assist, but if you don't intend to do it, right, if Larkin, for example, had been standing there and he didn't know what was going on, if he'd got there earlier and he didn't know what was going on, and the policeman came along and he says to the policeman, "Oh, look, I'm having a really bad day. My girlfriend broke up with me. Can you help me?" Or tripped him up or something like that, that actually delayed the policeman or stopped him from doing something. He might have assisted, but if he didn't intend to assist, okay, it doesn't count. You've got to actually intend the thing, right? Now, procurement is slightly different, because for procurement, because you've got to have this connection between what you're trying to do, you've got to have this idea that you are endeavouring to bring about the offence itself, then there's a higher mens rea requirement. Okay, so for procurement, you've got to show that the procurement requires a contribution that actually influences or induces the person to commit the crime, and that you intend to bring it about. Okay, so you've got to show that the actual act of procurement and that the procurement was intended to bring about the offence. Okay, so you've got a higher level of mens rea for procurement. You must intend the offence to be carried out. Right? Now just remember that recklessness does not suffice. It does for section 66.2, but it does not for section 66.1. And as I said, neither does accidental assistance. Okay, final mens rea. You must know the physical and mental elements of the essential facts, okay, of the offence. Okay, so really what we're talking about here is your actus reus mens rea. So you've got to have actual knowledge. Recklessness doesn't suffice, but willful blindness does. Okay, so if you have a suspicion that they might be going to do this thing, that's not enough. If you think, you're pretty sure, but you fail to inquire because you really don't want to know, right? You're willfully blind, then that will suffice. Okay, the courts will infer knowledge in those circumstances. So what actually are the essential matters? This is really where section 66.1 usually fails, or this is what it usually falls on. Okay, so the idea being that if you're actively encouraging someone or intending to encourage someone or assist someone, you at least know what it is they're going to go on to do for you to be liable. Now, in terms of your actus reus, the accused must know the principal intends or contemplates doing actions which form or constitute the actus reus of the offence. Okay, so you don't have to know all of the details. If someone is going to commit conversion, okay, they're going to steal a car, take it for a joyride, you don't need to know that it's a Subaru, silver Subaru. That's not an essential matter. Okay, you just have to know the actions which constitute the actus reus. You don't need to know that it's an offence. If you are ignorant of the fact that it's an offence, that's irrelevant. And you have to know this at the time that you offered your assistance or encouragement. Okay, so you don't need to know all of the details. It's enough that you knew the type of offence contemplated. So you must know either the type of offence intended or eventually committed, or any one of a number of offences that might be committed and the principal goes on to commit one of them. Now, one such case where you could commit anything of one of these offences and you go on to commit one was held in the case of DPP in Northern Ireland, which should start to give you some idea of the context of what we're looking at. In Maxwell, okay, so we're looking in 1978, so we've got a lot of IRA bombings going on, which I suspect had quite a big impact on the way that this was interpreted. It nevertheless provides us with an interesting principle in terms of if you are imagining that this person or had knowledge that this person could commit any one of these offences, if they commit one of them, you are liable. So in this case, the appellant was a member of an illegal organisation and they had been responsible for a number of murders and bombings. And on the night of the offence, one of these guys from the organisation, the IRA, came to the pub and they said to him, "We need you to come and guide a car through the dark to get to a remote country area." Now, this guy knew that he was being sent on a terrorist attack, but he didn't know exactly what the terrorist attack was. Now, the offence itself actually involved a pipe bomb, and it was thrown into a pub hallway. So he was convicted of doing an act with an intent to cause an explosion by a bomb, and he appealed on the basis that he didn't know the form of the attack or what form the attack would take. And the House of Lords said no. You have been properly convicted of aiding and abetting the commission of a criminal offence with knowledge of the type of crimes intended, and it was enough that you contemplated the commission of one of a limited number of crimes by the principal and you intentionally assisted in the commission of the crime. It was irrelevant that at the time that you lent your assistance, which in this case was driving the vehicle across a darkened field and through darkened rural areas, you didn't know which one was going to be committed. Okay? So, and you can imagine those circumstances. Somebody turns up at the pub, says, "Right, this is what you're doing." He's then held responsible for the bombing, even though he had no idea, but obviously, given the organisation he was involved in, that was enough. Okay, but knowledge that something illegal is going to happen isn't sufficient, which is your Bainbridge case. Now, this was a case where they had an aggravated burglary, and this, the principal offender committed the burglary, had a possession of a weapon, which obviously is what makes burglary aggravated. Okay? Otherwise, it's just simple burglary. And the court said that the possession of the weapon was an essential element of the offence that had to have been known by a secondary party, and if they didn't have knowledge of that essential element, then they can't be guilty of aggravated burglary. They could be guilty of, as a secondary party for burglary, but not aggravated burglary. Okay, because it was held to be an essential element, therefore you must have knowledge of it. Where it starts to get really tricky is where you're looking at mens rea levels. So where mens rea or a level of mens rea is a particular requirement, then you've got to show that the person, the secondary party, has knowledge of that level of mens rea. But where it becomes really difficult, and you'll see this when we come to have a look at section 66.2, is when we are looking at cases particularly involving manslaughter. Now, you all, I'm hoping, will remember that for a manslaughter case, what's your starting point? A few minutes left. Where do you start in a manslaughter case? If you're a prosecution, what do you have to show for a manslaughter case? I'm like, oh, really? That was first semester. What's she talking about? What's the first thing you've got to show? Yep. Yeah, you've got to show homicide, right? Section 158. You've got to show that one human being caused the death of another human being, directly or indirectly. Now, would you not think that the mens rea relating to the death of someone would be an essential element if you are a secondary party to manslaughter? Do you think that if you're charged as a secondary party to manslaughter that you have to know, you have to have knowledge of the mens rea, someone's going to die? What do you think? No, you don't. You're quite right, right? The knowledge that you have to have relates to the unlawful act. Okay, and this was the whole essence of the Burke case for anyone who's interested. If you read the submissions of James Rapley, who was the defence counsel in that case, that was one of the arguments he had, that surely this should be an element that you should be aware of. An essential element of the manslaughter case is that someone dies. Surely you've got to have an awareness of that. One, as an actus reus requirement, and two, that there is that the person is either reckless as to death or, but no, okay? So where it gets tricky is when you're looking maybe at murder, at felony murder, reckless murder, and trying to establish that as an essential element, the same level of mens rea. And you can actually have cases where you'll end up with a secondary party who can sometimes even be convicted of a higher level of an offence. It's rare, but it has happened, than the actual principal party, because their mens rea is actually higher. But what you need to remember, and I've just looked at the time, I've got 1 minute, what you need to remember in terms of your mens rea requirements, that your secondary party must have knowledge of the essential physical and mental elements of the offence that is committed. If they don't, okay, like the burglary case, aggravated burglary, then they cannot be held liable for that additional part if they're not aware of that essential element. All right, on next, obviously we've got workshops this week on next Tuesday, 66.2. Can I just ask, if anyone is still wanting to pick up their test script, I can bring the test scripts into my office. Can I see a show of hands or, yeah, okay, cool, I will do that and I'll let you know when you can come and collect them. Thank you. I'll just turn the mic off so you're fine.
Hello. Might be a bit of a silly question.
No?
But in terms of knowledge of the actus reus and the mens rea of the principle, you have to have knowledge of that specific principles, actus rea and mens rea. Say in your example of the bank, the safe cracking.
Yep.
If I put a PDF up on the internet on bankcrackersforum.com,
Yep.
that's an instruction manual on how to crack banks, crack safes.
Yep.
I know that someone's probably going to pick that up and use that. If they do, in fact, use that and rely on it, is that sufficient?
Well, no, because you wouldn't be knowledge of, you're likely to be charged with something else, but it wouldn't be for that. It would be actually stupid, but well, because it raises some of those interesting questions in relation to I don't know why, and I couldn't fix it. This is coming up a weird colour.
Yeah, right.
Which makes you, PowerPoint's strange.
Yes, okay. Thank you.
Yeah. Feel free to try and fix it. think you'd be liable for other things, but it wouldn't be. I've not seen it used in this way, but I mean, well, I'd rather see it used in that way than some of the ways in which I've used it. I mean, you know, when you look at the architecture,